and welcome to the Justice Committee's 7th meeting of 2020. We have apologies from Margaret Mitchell and Fulton McGregor. And I would also like, on behalf of the committee, to put on record our thanks to Jenny Gilruth for all her work on the committee and our best wishes in her new role as a Minister. Agenda item 1 is consideration of the Children's Scotland Bill. Can I refer members to paper 1, which is a note by the clerk, and paper 2, which is a private paper. And can I welcome our witnesses for this morning's evidence session, the Honourable Lady Wise, Sheriff Tate and Andrew Campbell, Legal Secretary to the Lord President, who is here as a supporting official. We have around 50 minutes for this evidence session, so if I can remind members to keep their questions brief, and if I could ask the witnesses to keep their answers as succinct wherever possible. So we'll move straight to questions from members. Question 1 from John Finney.
Thank you, Convener. And taking heed of your suggestion there, I'll try and roll a few questions together. Good morning, panel. I want to talk about children's participation in the decisions affecting them, and in particular, removing the 12+ presumption. Could you maybe outline what you think the practical consequences of that might be, please? And also, if you could roll into that, the situation with a possible new presumption, a right to express the views. So, the Children's Commissioner believes that all children have the capacity to form a view, and it's the view of the Scottish Women's Aid that there's a right for all children to express a view. Can you maybe give some outline of implications of that for yourselves, please?
Yes, of course. Perhaps I could just start by thanking the committee for inviting us to give evidence today. I'm sure the committee appreciates that it's quite difficult for sitting members of the judiciary to appear in this role, both constitutional issues and also practical and programming problems, and I'm grateful to our administrations for releasing us to do this, and we'd like to help and given the importance of the bill, make an exception on this occasion and
much appreciated.
Assist you as much as we can. And in relation to your first question, obviously my answers will be limited to my experiences as an individual judge, although I am familiar with and supportive of the Senators of the College of Justice response that you will have. So on the first question about the removal of the legal presumption in relation to children aged 12 and over, this is something that I personally am supportive of and that the Senators have been supportive of in our responses. On a practical level, we already elicit views from children younger than 12 years old, sometimes as young as 7, 8, 9. And the concern about the presumption in relation to age and maturity at the age of 12 is that it could be interpreted as a disincentive to elicit views from children younger than 12. Now, it's not something that we've had a practical problem with, but I think we welcome its removal in that it would clarify that it has to be a case-by-case approach. Every child case is different. Every child is different. Their circumstances are different. Their maturity is different. But we already take a case-by-case approach, and we intimate to all children unless we consider that they are too young or too immature or that they lack legal capacity to do so. So it wouldn't have much of a practical effect. So far as the Court of Session is concerned, I'll let Sheriff Tate speak about practice in the Sheriff Court. So practical implications are a few. In relation to the question about a positive presumption, I think that this may be a matter of drafting and not one that the judiciary should be involved in, because there are various ways of expressing these things. You can have a provision that, unless a child is insufficiently mature or lacks capacity, there will be the opportunity for them to express a view, or you can express matters in terms of a positive presumption. I think the concerns have been expressed about the difficulty of a positive presumption in the sense that then it would encompass all children from babies onwards unless they were exempted. And others, and I'll let Sheriff Tate speak to this, may have made points about the need for some form of capacity test or capacity examination rather in every case if all children are encompassed in a positive presumption rather than simply leaving it to the discretion of the court, which is the current situation. Sheriff Tate.
I would echo what has been said by Lady Wise. I mean, the presumption was put in place, obviously, when the 1995 Act came into force, and we've moved on quite some way. And I think that sheriffs now are much more mindful of the ability of children younger than 12 to be able to express views. You may be aware that recently there's been a lot of work done in relation to Form F9, and the whole purpose of that and the training from the Judicial Institute at the time was to remind sheriffs that children, much younger children, can express views, and they can express views in different ways. So I think that has raised awareness of the ability for younger children to give views. I don't have a difficulty with removal of the presumption, but I don't think necessarily it would be of benefit for there to be a presumption that all children are able to give their views. And of course, sheriffs, because of the statutory test, again, are mindful always to give consideration to views being taken where practicable.
Thank you both very much indeed for that. Can I follow up one aspect of that, and that is, and not in any way meant in a pejorative way, those on the bench, the training with which they're provided to engage with children if they're going to elicit these views, because it does suggest a one-to-one with children, many of whom have maybe suffered some adverse childhood experiences, or for whom the whole process is traumatic. What training is there, and is that something that you mentioned about the training associated with the form? I accept, but is there more that can and should be done with that regard, please?
In my experience, sheriffs fairly infrequently will meet with a child to take a child's views. But in terms of the wider issue of training, the Judicial Institute does run a regular programme in relation to child law aspects. And one of the key features in that is looking at various ways in which children's views can be taken. Would you want me to expand on what some of the difficulties may be in relation to meeting with children and taking their views as opposed to the other methods, or that may be a question later?
Yes, perhaps briefly, because I think you rightly identify, they're all individuals with individual circumstances. And
yes, I mean, I think that is the important thing, that each case is looked at on an individual basis, with quite a lot of information available to the court in terms of written pleadings, submissions from parties, representatives. Parties are often present themselves at a hearing when we explore how views should be taken. So there's quite a lot of information about the individual child. I think a concern in relation to sheriffs or judges meeting with children is not necessarily limited to the aspect of training, but there may be a tension between the fact that it is the judge who's going to be making the ultimate decision, and there may be a tension if they're to meet with the child and take their views, when ultimately they will have to make that decision based on a number of views, and the children's views will not be the sole factor and necessarily determinative. There can also be an issue in relation to transparency, because it's important that the child's views are available to parties, and so that submissions can be made in relation to those. And there is always the possibility that there may be a challenge to the judge's representation of what the children's views are, and that could potentially result in a difficult position.
Thank you. Lady Wise.
Yes, perhaps I could just add to that, and we may be straying into questions that you have later on about child welfare reporters and so on.
Yes, there are questions coming up later
and we can deal with those later, but I think the important a message is that in our experience, it is very much for the individual judge to decide the method of seeking the views of the child in conjunction with the representatives who make submissions about that. In the Court of Session, we deal with a number of different types of child cases. So we have everything from international child abduction cases where children have allegedly been removed from their country of habitual residence and may have a convention-relevant objection to return to the other country. We deal with cases where a parent wishes to move across the world to Australia, for example, and the children's views are being elicited on that. And then we have domestic cases where there may be allegations of abuse and where the children have to be questioned very carefully. So in any individual case, our experience is that what works best is for the judge presiding over the case to decide whether someone with expertise in speaking to children, such as a child psychologist, requires to be instructed, whether a member of the bar is best placed to elicit the views because of the acrimonious nature of the dispute, or very, very rarely, and it's not something we tend to do in the Court of Session, speak to the child oneself. So there are different ways, and we can come back to this when we talk about child welfare reporters, which is one of the most common methods of eliciting views of children and indeed looking at other matters. But I think the important point is that there isn't a one-size-fits-all. We have to be able to have the discretion to choose how best to elicit those views.
Thank you very much indeed.
Thank you. If I could ask you, please, about section 15 of the bill, which is about explaining decisions to children. I wonder if you could tell us whether you think, how that would work in practice. And if I could draw your attention to a submission we received from the Sheriff's Association. And they, in their submission, they say that this could be unduly onerous. And I wonder if I could have your opinion on that.
Yeah, I think it's important to think how it would work from the child's perspective. There will be a number of decisions made in relation to a child in the course of an action. Rarely, but it is possible, those that may even be pre-service, so before the action has even been served, there may be emergency orders made. There may be orders made at an early child welfare hearing, very much on an interim basis while further information is obtained. And so from the child's perspective, there may be a number of decisions being taken. And I think there could well be a concern about a child's ability to cope with regular meetings for those to be explained. You will appreciate that children are not present at these hearings typically, and so necessarily there would be a time delay before a decision could be explained to a child, and it is likely that the child will have met with a parent who will already have indicated what is going to happen. So from the child's perspective, I think there would be a concern about how exactly that would work. And again, I think it's very much down to the individual child. Some children may welcome that, other children may find it a situation that would be intimidating, perhaps an unwelcome situation.
And who do you think would be best placed to explain those decisions? I mean, you mentioned a parent there, but what if the parent doesn't? You said it. It can be quite complicated and have different stages.
Yes, and if we have a situation where there is a concern that the parents are not, because of the dispute, able to safeguard the children, that is the type of situation where there may already be a curator appointed to the child.
Mm-hmm. Yeah, but in principle, you agree that the child should know why the decision has been made and how it's been made?
Yes, but whether that, I would have concerns about a situation where a child, there is a report being made to a child on a regular basis. It very much depends on the individual child, and I think we have to be careful not to pull the child too much into the proceedings, and that could be quite a burden for the child. I think it also has to be remembered that there will be information which informs the court's decisions, not all of which may be apt to be shared with a child. For instance, there may be separate criminal proceedings, there may be various allegations, and whether it is appropriate for that information to be shared, I think should be carefully considered.
Okay, thank you. Lady Wise, are you?
No, I would echo that and just explain that the concern of the senators is the mandatory nature of the provision as currently drafted. The present situation is that if there was a concern that a decision of the court would be inappropriately conveyed to the child, that it wouldn't be explained properly in the adversarial process, that's something that parties can bring to the court's attention, or in a case where there's a child welfare reporter, that's something that might have been highlighted by the child welfare reporter who could then be instructed to do that. But it would only be in the rarest of cases that a parent who's going to have ongoing responsibility for a child would not be in a position to convey the decision to the child. And parental responsibilities obviously stretch to having to guide the child through difficult situations, such as the outcome of a court process. There are a number of practical problems and challenges that would arise if the court was to take on this new responsibility. But at the moment, it's not. We don't perceive there being current problems that have to be addressed. We don't have reports of children not having decisions explained to them in a way that allows them to move on after a litigation.
Thank you. Liam.
Thank you. Good morning. Sticking with the issue of the sharing of information, you'll be aware the government originally consulted on potential legal provisions for the sharing of confidential information where it was seen to be in the best interest of the child and where the child had an opportunity to express a view. Now, those provisions weren't taken forward. We've heard evidence from some stakeholders around concerns that some very highly sensitive information that a child may have provided in the expectation that it wouldn't go out of the room, so to speak, could now be brought into scope. And I was just wondering whether you could explain the way in which currently that confidential information is managed, and whether or not there are any concerns that the bill doesn't, as it stands, go further in terms of protecting the confidentiality of what could be quite sensitive interactions with adults in the system.
Yes, in a case where there are very sensitive issues, you would anticipate that a child welfare reporter would have been appointed or a curator. And when that appointment takes place, certainly in relation to a child welfare reporter, there is a form, the F44, a very detailed form where very careful directions are given to the reporter, and one section in relation to that deals with the issue of in the first instance, whether the children's views should be reported separately to the court and so are held as confidential. What will happen at a child welfare hearing when that report is available and the views are separately available to the court is there will require to be a discussion in relation to the status of the views and where appropriate for the views to be shared, but in a way which is in the best interests of the child and mindful of the issue of confidentiality insofar as possible. But you will appreciate that the court is making a decision based on information and so has to give some indication of what factors have informed that decision.
I mean, one of the I suppose the concerns that was raised was about the proportionality of the information that was shared, and rather than, I suppose, whole case files simply being handed over lock, stock and barrel, that the information that was pertinent and relevant to a particular case would be extracted, could be shared appropriately, but other information that may be sensitive but may not necessarily have a bearing on the case would remain would remain confidential.
So I think we're going beyond simply the views of the child.
Yeah.
In relation to recovery of documents, then that would be by court order. There would be an application in terms of a specification of documents, and the court would be able to give careful consideration to the information which is being sought, how that would assist. And again, there is a mechanism for confidentiality in the recovery process. So there are mechanisms in place for document recovery, for disclosure, and that is managed by the court.
Lady Wise, is anything?
Yeah, I just want to add, yes, that under the current system, you mentioned recovery of files and being handed over, lock, stock and barrel. That's not something that happens because the child, unless the child's a party to the proceedings, which would be very rare, documents are recovered for the process and they're dealt with sensitively and appropriately by everyone in the courtroom, the representatives and the judge. We also anonymise children's cases, so when you ultimately reach the stage of a decision, a court decision, court determination, then there would be nothing to identify the child, and any sensitive or confidential information would be treated in a way that meant there wouldn't be identification of the child.
Okay.
Thank you. Liam?
Thank you, Convener. Good morning. Where a court order is disobeyed, or the court is considering a finding of contempt or a variation of that order, there's a new section 16 which imposes a new duty to investigate the circumstances behind that breach. Now, some of the evidence this committee has been very supportive of that, particularly suggesting that this is not what happens at the moment in terms of an investigation. On the other hand, faculty have suggested that this investigation will happen anyway, and we've had other evidence suggesting that such an investigation could actually prevent robust enforcement and actually encourage people to disobey the initial order. What is your view, and can you help the committee understand what does happen at the moment?
Perhaps I'll just deal with that first. We have recent experience of contempt of court proceedings relating to orders relating to children, where the court has made an order and it has not been adhered to. Perhaps children haven't been handed over from one parent to the other or one jurisdiction to the other, which would be the sort of case we'd deal with in the Court of Session. Now, in those proceedings, which is the current way we deal with it, there is always an opportunity for the party who is said to be in breach of the order to respond. And I think very importantly, the defence that would typically be stated would be that the breach of the order is not willful, that perhaps it had been too difficult to encourage, persuade or direct a child who might be 12 years old or something to go along with the order that the court had made. And so if the concern is that current procedures don't take into account that there may be circumstances out with a parent's control why an order couldn't be obtempered or complied with, then that is something that's already built in to the current way in which we look at alleged breaches of orders. The provision as currently drafted could read as an invitation to those who do not wish to comply with an order to raise the question of variation or discharge of that order as an answer to an allegation that they have breached it. What I can reassure the committee on is that cases where it is said that someone has failed to obey an order, to breach an order, are dealt with very carefully, and there is an opportunity for the person against whom the allegation is made to be heard, to be represented, to address fully, and the court would never impose any sort of punishment without being satisfied that it had conducted a fact-finding exercise on that. want to add anything to that?
No, I think I would echo that. I mean, clearly a decision which is made by the court is made in the best interests of the child, so it must be of concern if one parent is not prepared to observe that order. If a parent considers that the decision, for whatever reason, is not in the best interest of the child, they have the right to appeal that order. And I think it's important that the proposed section doesn't, in essence, confuse an appeal against a decision which has been made into the proceedings which are really looking at the failure to obtemper.
Just to follow from that then, and I appreciate you may not wish to answer this question directly, but is it your view then that Section 16 may be unnecessary and this committee may consider not going forward with the Section 16?
So the view of the senators of the College of Justice as expressed in the response from the court was that the provision is unnecessary for the reasons that I've explained.
Very grateful. In consultation in 2018, the Scottish Government suggested or consulted on alternative sanctions, but that hasn't appeared in the bill. Do you take a view on the sanctions available and the process behind the sanctions? And do you take a view on whether those problem-solving approaches could have been in the bill?
I think it follows from the answer that I've just given that the current procedures, both in terms of the opportunity to be heard and then the wide discretion the court has to impose whatever sanction is appropriate, are currently adequate. That's our experience.
Very grateful. Sheriff?
Again, I would echo what's been said by Lady Wise. Thank you.
Thank you very much.
Thank you. Shona?
Good morning. I wonder if we could just return to the issue of child welfare reporters touched on earlier. I have a number of areas to explore. The first is on the local or national lists. You will be aware, obviously, of the discussion and debate around this. The issue really being driven around concerns about the lack of consistency across the country on various issues. Issues around training requirements, skills and experience, quality and cost of child welfare reports. So just for the record, do you think that there is merit in changing that, or if you think it should remain local, how could these issues be addressed in that case?
At the current time, obviously, we have a local system and my experience, my personal experience of that is that it works well. We have a number of very experienced child welfare reporters, and my experience is that the quality of reports which are produced is high. It is accepted that training would be of benefit, and I think that the focus really should be on training rather than necessarily changing the nature or the type of person who is appointed. When we look at cases on an individual basis, it is helpful to know the local skills, know who the reporters are, and in particular cases have the discretion and the flexibility to appoint a reporter who has skills which would be of benefit in a particular case. So I think the flexibility which we have at the current time is of value, but of course training is always something to be welcomed.
And though that set of skills surely that could also apply to those without necessarily a legal background, with a psychologist, for example, as long as the training was there. Is that something you would?
Yes, and at the current time, the court gives consideration to who's the most suitable person, and that may, in more complex cases or given the needs of a specific child, be a child psychologist. So we have that flexibility. In some circumstances, but relatively few. It may be that a report is sought from the social work department. So at the current time, we're not necessarily only appointing solicitors as child welfare reporters. We do have other parties who can be appointed in appropriate cases.
And just on that issue of appropriate cases, there have been issues raised about the scope of the reports that are requested by the court. So, for example, whether could a court routinely ask a child welfare reporter to consider a child's relationship with other family members, such as siblings and grandparents? Those are issues that have been raised in the evidence that we've taken.
When a decision is made to appoint a child welfare reporter, the court has available to it the pleadings for both sides, and will also hear oral submissions, and will have been aware of what the issues are before in preparing for the hearing. So the court will have an idea of what are the issues. So in a particular case, is there an issue about maintaining contact with a wider family, and would that be of benefit to the child? So where that, if that is a specific issue, yes, the court can direct the child welfare reporter to interview the relevant parties and to report on that. But in my experience, the reporters do look holistically at the child's situation, and so we do tend to know about the role of other members of the family where those roles are significant.
Okay. Finally, on the issue of fees for child welfare reports, the policy memorandum of the bill suggests that fee rates for reports could be set in a variety of ways, such as an hourly rate, or by report, or by page by page, and so on. Do you have a view about the setting of fees?
I don't think that would be appropriate for me to comment upon. I don't have an involvement in the fees at the current time.
And just finally, you said earlier that, in your experience, the system currently works reasonably well. Would you accept, though, that perhaps that's not necessarily the case elsewhere? We've certainly, some of the evidence we've heard, there have been some concerns raised about consistency, about training, about quality. Would you accept that, although your experience has been perhaps different from that, would you accept that perhaps elsewhere that's maybe not necessarily always the case?
Again, it is difficult to comment on that. I mean, I have sat in a number of sheriff courts in Scotland, and I haven't found a difficulty with the quality of the reports.
Okay.
Thank you.
Yes, maybe I could just come back on one or 2 points. There are a number of issues, obviously, that arise out of the proposals on child welfare reporters, and the stage of a case in relation to a child in which a child welfare reporter will normally be instructed or appointed is at a relatively early stage before the court has conducted the ultimate fact-finding exercise. So the purpose of the child welfare reporter, in my experience, is to assist the court with an interim situation pending final resolution of the case. One of the reasons, and it may seem curious to some people that we send lawyers out to speak to children and investigate the circumstances in which they live, but of course the lawyers in the case understand the backdrop to the dispute. They understand that allegations made but yet untested are something that they have to deal with in a particular way. And they also understand fundamentally that they can't usurp the function of the court. It's not for them to tell the court what to do, or even, in most cases, recommend to the court what to do. So they are providing information that the court can't go out and get for itself. Mm-hmm. So it's for that reason that the current system, where we have a list in the court of those who are willing and able and have the necessary PVG certification and so on, is a we find a helpful method of being able to regulate who we send out for a particular exercise. And I won't repeat what I said earlier about the very different types of cases in which we might have to do that. It is helpful, of course, that we have a variety of people on that list, be they solicitors or not, or in the Court of Session, usually advocates. So the court maintaining the list is helpful because I think there would be practical difficulties if that was not within the court's remit. It works well at the moment. The training issue is one that the judiciary has raised repeatedly. I think it is important that all of those who are sent out to examine the circumstances in which children are living, whether or not they're also eliciting the views of the child, are properly trained. Now, the faculty in the Court of Session, we have the benefit of a very active Advocates Family Law Association, and they have provided training for their members, and I understand are willing to continue to do so. And there's a good relationship between bench and bar such that the court is satisfied that those currently on the list are suitable and appropriate. I'm not quite sure how that would work if the list was not maintained and regulated by the court. The other thing I should say is that while I absolutely agree with Sheriff Tate that the judiciary can't be involved in commenting on financial matters and the implications of this, in the Court of Session in particular, it is less likely that parties will qualify for legal aid. And so at the moment, the system that we have, and there's a default position in our court rules, is that one party or the other bears the burden of the cost of a child welfare reporter in the first instance, and then the court has the power to regulate that later on when dealing with the expenses of the case.
Okay, just for absolute clarity, when you talked about the list and the skill level and trying to match the appropriate person to the case, are you saying that that doesn't necessarily have to be somebody with a legal background as long as the skill level and qualification and checks and so on are in place?
Yeah, so we find that it works well having legally qualified child welfare reporters for the reasons I've explained about them understanding the backdrop, the nature of untested allegations and the adversarial process. And they will be lawyers who are conducting cases in the Court of Session already, but they would be independent for that. Like Sheriff Tate, I have no difficulty in principle in a suitable case with somebody who is not legally qualified, of course. And I gave the example of appointing child psychologists in appropriate cases. Okay. And there are situations where that particular expertise has been of great assistance to the court.
Okay, thank you.
Thank you. Yes, can I just remind members and witnesses we're kind of up against the clock, so if we can keep our questions and answers a bit succinct. Supplementary from Liam. Thanks
very much, Convener. Just following up directly on that, you may or may not have seen the additional evidence from Dr. Sue Whitcomb, which I think has come through the British Psychological Society, and she said that the Law Society of Scotland's Standards of Conduct Rule B1 110 clearly states that solicitors must only act in those matters where they are competent to do so. For many years, solicitors have been drawing conclusions and making recommendations on matters of child welfare when they do not have the appropriate professional skills nor the competence to do so. So I think while the understanding of the legal process in the backdrop is very much the preserve of solicitors, I think the point being made is that in terms of welfare and getting to the understanding of issues of attachment, etc., that is not necessarily where their strengths lie, and this may call into question the competence to do it. I would welcome any comments from the panel on those statements.
In more complex cases, for instance, where issues of attachment or there may be issues, psychological issues, my experience is that child welfare reporters will not seek to reach a conclusion which is out with their competence, but they will signpost what further investigation may be required. And again, I think it's back to this issue that the child welfare reporter is normally being appointed at a very early stage. There may be certain factual disputes where the court needs further information, and it may be that in providing that further information, the position of the child welfare reporter is that there should be instruction of a child psychologist or some other form of therapist, family therapy, something of that sort. So in my experience, that is often reported back to the court. And of course, the court would be very aware and would be concerned if a reporter were to seek to reach a conclusion which was out with their competence.
Could I just add to that it's not the role of the child welfare reporter to make recommendations about what happens in the case. Overall, it's very much for the court to decide, applying the legal test, what is in the best interests of the child. And all that matters in these child cases is what's best for the child, with that child's welfare being the paramount consideration for the court. The purpose of any reporter, be they a trained child psychologist or a member of the bar, is to assist the court in having all relevant material and information before it so that the court can make that decision. So it's really an information gathering exercise primarily.
Thank you. Can I ask you please about section 9, it's contact centres. In evidence to the committee, the domestic abuse organisations and several children's organisations have questioned whether the courts should be authorising contact between a parent and a child which without professional supervision would be unsafe. Can I ask you why you do refer people to contact centres, particularly for supervised contact?
I can't imagine a situation where the court would consider that it was in the child's best interest to order contact if there were concern about risk and safety of the children. So,
sorry to interrupt, but you do accept that that's what happens because, you know, supervised contact is ordered at contact centres? That's what happens regularly?
Well, I'm sorry, I'm not certain what circumstances you're referring to, so it's difficult for me to answer that. Contact centres are used regularly where it's considered. You'll be aware that there are two forms of contact. There is supported contact and there is supervised contact. And it's difficult to envisage that the court would order that if the court considered that was not safe for the child.
Right, okay. Can I ask you then about regulation of contact centres? In the submissions we received from the Summary Sheriffs Association, they say that contact centres should not be disadvantaged by regulation. The Sheriffs Association say they would welcome them in principle, so there seems to be a bit of a disconnect there. But I mean, we have heard some concerning evidence from children who've experienced them and from the women's organisations and children's organisations about contact centres, and the sort of evidence we've received almost unanimously would like to see some sort of regulation. So I'm wondering if you're prepared to comment on that.
I'm afraid I don't have direct experience of those concerns, so I'm sorry, I don't think I can assist further with that.
Okay, Lady Wise, would you?
It's not something that I have direct experience of. I understand that contact centres are a valued resource, and particularly in the Sheriff Court, orders will be made for contact to take place at those. And the only concern, I suppose, about regulation would be whether it reduced the number of available contact centres. But it's not something that I have experience of.
Okay, Relationship Scotland, who provide the service in contact centres, as you know, said that there are sometimes gaps in the information that the contact centres get from the court, and they don't get a full picture of the family concerned as they would wish. So would you agree that perhaps that's something, there is a gap there, that maybe that's something that should be addressed, and are you aware of any issues around that?
Again, I'm sorry, that hasn't been fed back to us. I think I had one case where there was a report from the contact centre before the contact started, so at the point of the intake appointments, where the centre was concerned that it may not be suitable. That information was fed back. There was further inquiries. By that point, there had been some developments with the social work department, and the contact took place under supervision of the social work department. But that was a dynamic situation, so the situation had changed from the point where the court made the order. But that has been my only experience where it has a concern from the centre has been relayed and was relayed appropriately. And that wasn't because of anything which happened. The contact didn't start in the centre. There had been a development and social work involvement after the order was made. So there was an appropriate, the centre raised concerns, and those were taken on board, and alternative arrangements were made.
I think the concern is that without regulation, standards are not, you know, they're not, there's no real framework for them throughout the country. So it could, you know, the standards in each of them could be very different. So your experience and then another area might have a different experience. So I think that was basically the concern. So given that we really have heard some concerning evidence about this, do you think there should be more, that courts should have more access to specialist risk assessments before referring to a contact centre? That's something that Relationship Scotland have suggested might help.
Again, there are cases where risk assessments are undertaken, not routinely, but where the facts in a particular case indicate that is appropriate.
Lady Wise?
To add to that.
Okay, thank you. James?
Thanks, Convener. Can I just look at sections 4 to 7 of the bill and the impact that will have in practical terms on court time? So sections 4 to 7 obviously deal with support for vulnerable witnesses, and 4 to 6 in particular concentrate on the proof in cases, and section 7 concentrates more on child welfare and family cases. Obviously it's a concern if there are delays in court cases. Do you think there are going to be sufficient resources and infrastructure in place around these additional measures without court delays being as a result of the additional assistance that's got to be provided?
I mean, obviously we're used to a very similar provision operating in the criminal courts, and it seems to operate without too much difficulty there. I think the provision certainly has to be welcomed in relation to representation of a party, so that and where there are allegations of domestic abuse, a party is not being questioned by the alleged perpetrator. So that, I think, has very much to be welcomed. The issues may arise in relation to child welfare hearings, which of course are important hearings before the court can come finally to a proof. At the current time, when the court normally through court staff is made aware that there may be difficulties, perhaps because of bail conditions or other factors about parties being in the same room, we are able to make arrangements for there to be separate waiting areas for the parties to arrive to hearing at separate times, and perhaps further to be a shuttle hearing. It is relatively infrequent for those requests to be made, but certainly we have been able to accommodate them this far.
Just in terms of specifically looking at the provisions of the bill, you know, if you look at section 7, for example, around, you know, special measures that would be introduced there, and there is a suggestion that you know, there could be a greater extent of problem solving involved to try and resolve disputes. Do you think that can be progressed without there being delays to the ultimate timescale for the resolution of the case?
I mean, obviously, the witness support services are going to be important, so there will be an issue around availability. I think in terms of timetabling and the conduct of proofs, simply that will become an integral part of those in exactly the same way as these measures are an integral part in the conduct of criminal trials. So I don't think there should be any delays occasioned by that.
Perhaps I could just add that I have some recent experience in family actions in the Court of Session of using the provisions of the 2004 Act to adopt the same sorts of special measures as we routinely use in the High Court, the use of screens, a supporter, evidence being given through live link, that sort of thing. So these are considerations that we already look at, and I think that the prohibition on questioning by a party if there are allegations of the type mentioned in the bill is a useful addition to that.
Turning to section 21 of the bill, which looks at basically dealing with, you know, the court having regard to child welfare where there are delays in court cases. Do you think that's a helpful provision?
There is a body of case law that already directs us that any delay or protraction in proceedings relating to children is likely to be detrimental to their welfare. So it's something that the courts and the judiciary are very well aware of already.
So do you think that section 21 is helpful in that regard, or is not required?
It's a provision that, from my perspective as a judge hearing these cases, I wouldn't regard as necessary. It doesn't add anything to the existing position, which is that we are all well aware that delay can be disadvantageous to children, and children are at the centre of what we do in the courts. I don't know whether it would assist in resourcing if it was felt that there weren't enough courts available or judges available, and this may be more important in the Sheriff Court than in the Court of Session, where we have 2 dedicated family law judges and it works well. But certainly, unless there is a feeling that there are delays caused by there being insufficient judicial resources, then at the moment this is a factor that is very much uppermost in our minds when we deal with child cases.
Do you think there's a case for prioritising parenting dispute cases over criminal and civil cases?
Well, criminal matters take precedence over civil matters generally, and I'm restricting myself to the High Court and the Court of Session. We are very fortunate in the Court of Session in that we have very good administrative arrangements, and the keeper, who's the person who allocates the cases, would always give priority to a child case in particular. There are other types of family cases that are also given reasonable priority, but and not so much priority if they don't involve children. So we already give priority to children's cases to avoid the sorts of delays that may have happened in the past.
Okay, thank you.
Thank you. Just in the few minutes we have left, I would just like to ask you about, go back to the question of judicial training, and whether you agree with several stakeholders who have suggested there needs to be greater judicial training on topics including domestic abuse and child development and effective communication with children. And what is your view on specialist family sheriffs or the creation of specialist family courts? Do you think that would be helpful to address some of the issues that the courts are currently facing with regard to delays, etc.?
Again, in relation to the issue of judicial training, that's managed by the Judicial Institute. I'm not certain whether they've given evidence in the current round of proceedings. There are, on an annual basis, regular child and family law sessions, and all members of the judiciary, so at every level, in the last, I think, 18 months, has undergone a specific training in relation to domestic abuse, and I think that training programme is now complete. As far as the issue of specialist courts, I'm aware that the Sheriff's Principal have responded, and also the Lord President, and clearly it's within their remit, the organisation of business.
Just to clarify, is that training mandatory or voluntary?
In the training in relation to domestic abuse was mandatory. All members of the judiciary undertook that, with considerable input from Scottish Women's Aid and various other organisations. That was a one-day course in person, and we undertook various exercises, and there was distance learning, perhaps of about, I think, 5 hours duration in advance of the course.
Thank you. Lady Wise?
Yes, in relation to the issue of specialisation and having dedicated family courts and family judges, in the Court of Session, I've already mentioned we have 2 specialist family judges, of which I'm one. In large sheriff courts like Edinburgh Sheriff Court, where Sheriff Tate sits, there's a similar regime. It is more difficult, I think, when one looks at rural courts and courts with fewer sitting sheriffs, to have absolute rules about specialisation. But of course, sheriffs are trained to deal with a wide range of civil and criminal matters. And as Sheriff Tate has already mentioned, there is a training through the Judicial Institute on behalf of the Lord President that works well.
Thank you very much. That concludes this evidence session. Can I thank you very much? It's been a very helpful session to us. Thank you. So we'll pause briefly to allow the witnesses to leave. Feedback from the Justice Subcommittee on Policing on its meetings of the 30th of January and the 6th of February. As we are short on time, paper 3 will stand as the feedback from these meetings, if that's okay. And thank you. That concludes our 7th meeting of 2020. Our next meeting will be on Tuesday, the 25th of February, when we will take closing evidence on the Children's Scotland Bill from the Minister for Community Safety.